Ladies and gentlemen, this is Bruce from Oregon, Bruce the Moose with the Bruce from Oregon Show. This could be episode 0, it could be the first, it could be the last. Nobody knows. We're going to try and find out. I'm coming to you pre-recorded from the Moose Tech Van. I have a van tour video going up on my channel pretty soon. Check that out. But today what we're going to do is read through one of the motions to quash in the Lively v. Baldoni case. Now, subpoenas went out to dozens of content creators. No subpoenas to me because I only have like 2 videos on this case. Nobody wants to subpoena me. That's for the best, guys. That's all the best. Now today I've got my reading glasses on and we're going to look at the fine print and we're going to read through one of the many motions to quash that are now hitting the docket tonight. It's 7/23/2025. Later tonight, as I'm recording this, Lauren is going to go live with Omar to talk about all of these motions to quash and what Omar thinks about them. And so that'll probably have already happened by the time this video makes it out of my van through the space age internet satellites and cell phone towers and wires and tubes. The internet is just tubes, guys. They're tubes. And sometimes the tubes are slow, but we'll do what we can. But by the time you see this video, it'll be there and you can watch it and listen to a dramatic reading. I don't know how dramatic, okay? Maybe a little dramatic? I don't know. A dramatic reading. A dramatic reading of one of the very exciting motions to quash. This one is non-party movement. Ashley, Briana, Eve. Now, I was over on Ashley's channel in the comments section and she was saying, oh my gosh, I don't know if I feel comfortable reading my own motion to quash on YouTube. That's a little weird. Maybe somebody else will read it. Maybe Bruce will read it. So here I am. I'm Bruce. I'm going to read it. Let's do it. Let's get into it right here. So we've got all the case details up top. That's fine. Blake Lively petitioners v. Wayfarer Studios LLC. It's all defendants. Okay, let's get into it. Please take notice that non-party movement Ashley, Briana, Eve hereby moves this court to accept this pro se motion to quash pursuant to federal rules of civil procedure and to quash or revoke the subpoena issued to Google LLC dated July 3rd, 2025. Okay. Seeking personally identifiable information and private data associated with Movement's YouTube account, Ashley, Briana, Eve. So Ashley is a movement. A movement. It's a nice title. She's not the petitioner. She's not the respondent. Not the defendant. She's a movement. Makes sense. Let's keep going. I am filing this motion pro se whilst preparing to sign counsel for this matter because there are conflicting dates to respond and I want to ensure there is some sort of response on file before the deadline that appears on the subpoena, which is July 16th, 2025. I have very little information on this subpoena. Some accounts have not yet received a copy, even at this late moment. It's lawfare chaos, guys. It's chaos. It's chaos out here. So we're doing what we can. We're filing the motions to quash. And because counsel named as the serving party of this mysterious subpoena has been extremely evasive and uncooperative in addressing our questions and concerns, as this document will show. Very good. Due to my Canadian citizenship, I will be making my arguments based on both Canadian and American laws. Oh my gosh, guys. It's the American-US Canadian crossover we never knew we needed. Oh my gosh. As a human-shaped moose, I approve. Okay. Google has given us a respond date of July 31st, 2025. So that's coming up. But their subpoena request is due on July 16th, 2025. All right, and that's already gone. Exhibit A. For reasons that will be revealed in this document, oh, we got big reveals coming up. I am in fear that tactics may have been employed to cause confusion and or delay so that I will miss my chance to file on time. Google asked for an official court-stamped filing to be forwarded to their legal department to begin steps to quash their subpoena for my information. Okay, so they're looking to file something with the court to get the court to put it in the docket so they can send it to Google, and then Google can have their lawyers go buck wild on this case. Very good. That is why I am filing this today ahead of being joined by my counsel. I feel I need an official record of my response and intent. Additionally, I wish to have this letter filed to make the court aware of the types of abusive, sweeping subpoenas being served by Blake Lively at this point in discovery, since she stated in docket 410 that she has served 60 third-party subpoenas and intends to file several more motions for alternative service subpoenas, the same as those that have been served to Movement. This is nothing but an unfounded fishing expedition. See Exhibit B. And I'll let you know what Exhibits A, B, and so forth are at the end of this. We'll go through that. The titles of those exhibits. Okay, Section 1, Introduction. Oh my gosh, guys, this is a long document. It's a big one. This motion to quash subpoena refers to a subpoena served on Google LLC seeking the unmasking of 16 mostly anonymous YouTube and TikTok creators under the premise that we are engaged in a smear campaign against plaintiff Blake Lively. Exhibit C. The subpoena is unsupported by evidence, chilling of constitutionally protected speech, and endangers the safety and privacy of non-parties uninvolved in the litigation. Ms. Lively, who still cannot accept the criticism against her online, is completely organic and of her own making, has made yet another move guaranteed to make matters far worse for her reputation by lashing out at content creators on social media. And this is a good point. It reminds me of that thing called the Streisand effect, where if you try to get people to stop talking about something, they just talk about it more. And that's what's happening here with these subpoenas, I think. Let's keep going. She has apparently failed to sufficiently prove her case of retaliation, and with deadlines for discovery looming, has engaged in a last-ditch effort to bring a fishing expedition in the hopes of just maybe finding a connection between any Wayfarer party, including counsel, and some of the negative online reports. She is barking up the wrong tree. Oh my gosh, we've got trees, guys. Trees have entered the chat. Section 2, Factual Background. Movement is number 15 of 16 independent online commentators who lawfully analyze court filings and publicly available material related to high-profile litigation. Very good. Movement, like all others listed in the subpoena, does not have any affiliation or communication with the defendants, defendants' counsel, or anyone related to defendants in this matter. On or about July 10th, 2025, Movements received notification from Google that their identifying information, including names, emails, addresses, IP logs, payment data, and other personal information, was sought via subpoena in this action. And again, guys, that's a lot of stuff. Look at this. IP logs and payment data. Okay, through Google from people with YouTube channels. Does that make sense? How are you going to prove a smear campaign looking at Google financially interacting with content creators? By looking at Google, and when videos are uploaded, videos can be uploaded anytime. They can be launched anytime. You can upload videos and release them later. None of this information they're seeking is going to directly link a smear campaign from Wayfarer or the Tag talent agency group to these content creators. It's unbelievable, guys. Okay, let's keep going. We got a lot to get through here. Since that date, other creators are still receiving their initial notifications. At present, I only know of 8 of the 16 listed in the subpoena. Not all of us have received a copy of the actual subpoena. I fear many will not have the chance to fight this subpoena due to not receiving notification. That's a fair concern. Timing is everything, guys. The subpoena issued by plaintiff's counsel, Ezra Hudson, requests the following from Google. 1. Names, addresses, email accounts, and phone numbers, including backups. Any information plaintiff wishes to collect regarding Wayfarer and communications with the media should be requested directly from Wayfarer instead of chasing down every account on social media that may have made negative remarks about Miss Lively. Yeah, it's certainly more efficient if you have a single point of contact like Wayfarer Studios or the Tag Group, and then you're worried about a bunch of content creators, a zoo of content creators. The fan out is what we call that. The number of content creators is very high. It's a long list. It's way better to go look for the evidence you need from the source in this matter rather than the destinations, because there are fewer sources and many, many more destinations. So this is a good point. Number 2, IP addresses, login histories, and geolocation data. Plaintiff has not explained, nor is it easily apparent why movements' locations have any bearing on this litigation. Plaintiff has further not explained why they want this information going back to May 2024, when Movement did not begin speaking about this topic until December 28th, 2025, following the New York Times "We Can Bury Anyone Inside a Hollywood Smear Machine" article. Prior to this, I was unfamiliar with Justin Baldoni or any other Wayfarer party or their counsel. I was only aware of Miss Lively as the wife of Ryan Reynolds, not for any of her own accomplishments. Oh boy. Furthermore, Ms. Lively herself makes a compelling argument that individuals have a constitutional right to privacy regarding their financial information. In her response to the Wayfarer party's motion to compel her to disclose her own financial information, in litigation she elected to initiate and seek damages where she states, "This argument fails woefully short of overcoming the general rule against seeking party assets and financial information and Ms. Lively's constitutional right to privacy of the same." And you would think if you were looking for financial information, a petitioner or a respondent, they would be a much better party to investigate their financial information compared to these third-party movements, these content creators. They're not even involved in the case. So it's not even the same. There's a bigger likelihood that you'd want to go look at Ms. Lively's finances or Mr. Baldoni's finances or these businesses that they're involved with compared to these content creators. I mean, it doesn't make any sense. Okay, Section 3. YouTube and Google pay account information, including payment sources. YouTube neither directly pays their creators, nor do they use Google Pay. No third party has access to add additional money to a YouTuber's monthly pay. We are paid by AdSense, that's Google AdSense, okay, from Google, not from YouTube, not through the Google Pay financial streams, but AdSense, according to ads run on our channel. Ironically enough, Mint Mobile often runs ads on my channel featuring their spokesperson, Ryan Reynolds. So if I've been paid directly or indirectly by anyone involved in this case, it's former party Ryan Reynolds. And that's true. Somebody was mentioning, you know, the video I did on the deal, what's the deal with these subpoenas? They said they saw some Mint Mobile ads. I mean, I'm not picking those ads. It's all Google AdSense. It's all AI bots, you know, figuring out what ads are good to run on what channels based on demographics, you know. Maybe people that are watching this case are interested in having a cell phone. I don't know. Maybe if you're watching different types of videos, you'll be exposed to different types of ads for, you know, saltine crackers or, you know, trash can liners. I don't know. Anyway, let's keep going. Number 4, bank account and credit card information. One finds themselves astonished at what could possibly be gained by accessing credit card information, as everyone understands, or should understand, that credit cards are used for purchases and not for payments. Exactly. So if you use a credit card to sign up for YouTube Premium as a content creator, because if you're a content creator on YouTube, you're probably watching a lot of YouTube yourself and you don't want to watch all these ads all the time. So you will probably sign up for YouTube Premium with a credit card through Google Pay, for example, or some other mechanism direct through the credit card. And that has nothing to do with any chain of evidence that would be involved in a smear campaign. So it's very strange. Very good. Plaintiff claims to be looking for signs that I, as a creator, am somehow being paid by someone outside of AdSense to create my content. I am not. This request for Movement's financial records is overwhelmingly invasive. I restate that any information plaintiff wishes to collect regarding Wayfarer and communications, or payments with media and social media, should be requested directly from Wayfarer instead of chasing down every account that may have made negative remarks about Ms. Lively and demanding I show my, and anyone whom I share a bank account with, private financial information. I fail to see why information such as bank numbers would be required for any other purpose than to issue a further subpoena to the financial institutions with whom I conduct my business in order to obtain fuller financial records which have no relevance to Ms. Lively's claims that are grossly intrusive. Furthermore, this information would be futile to Ms. Lively as I am a Canadian citizen and resident, and a subpoena served on myself personally would be unenforceable. Okay. And even if it's not unenforceable, this is really big overreach here to be asking for credit card numbers or bank account numbers that are signed up with Google Pay so that you can go get YouTube Premium. It's ridiculous. Okay, number 5, subscriber registration data, premium services, and account usage history. It is unclear what this entails as far as my subscriber registration data or what premium services have to do with any part of this litigation. This request needs clarification if the court, as it usually does, grants her this invasive subpoena. Does this mean channels I subscribe to or channels that subscribe to mine? Is it premium services I subscribe to or premium services used to subscribe to me? And finally, what is a YouTube Premium service? We cannot control, nor is it an easy task to keep track of who subscribes to our channels. I restate that if Miss Lively wishes to know if a member of the Wayfarer party or council subscribe to my channel, this question should be directed to Wayfarer and not to me. I firmly object to my channel being used as a means to investigate people who subscribe to me so that Ms. Lively can add more innocent people to her desperate and paranoid list of possible culprits in an imaginary smear campaign. Yeah, I mean, it's so crazy because premium services could mean YouTube Premium. It could be somebody doing a super chat. It could be a content creator who's monetized and they're signed up with the content creator program, which is how you get the AdSense revenue. Are these premium services? Are all of them? Are some of them? We don't know. When they say subscriber, are they talking about the content creator who has a YouTube account, an account holder? Or are they talking about people who subscribe to the channel? Are they talking about metrics about subscribers, like the number of subscribers that somebody has on a channel, which you can go find out just by looking at a channel. You don't need to issue a subpoena for that. So the language in the subpoena itself is not as precise as I would like to see it. And I think this point number 5 covers that very well. Okay. To stall and confuse movements in the limited time we have to file a motion to quash this subpoena, it is believed that attorney Ezra Hudson allegedly instructed the receptionist at her law office, Manat, Phelps, and Phillips, to avoid the truth when asked about the authenticity of these subpoenas. Oh my. One movement's attorney was told 3 times that the subpoenas are fake. Dang. On another recorded phone call, transcribed here as Exhibit E, one YouTuber was told that Ezra instructed her to say, "We don't know, we're trying to work it out," if asked about them. Oh my gosh. It's chaos, guys. There has to be a runway where you can take an action, everybody can take in and see that action or see the documents, and then has time, sufficient time to respond to them. And this just seems like scheduling chaos, which again is just sort of a management problem, right? Clock management. Okay, let's keep going. Movements have been left with little time to respond before the deadline stated on the subpoena. Out of an abundance of caution, I am adhering to the date of July 16th, 2025. Very good. Section 3, legal standard. Under Rule 45, a court must quash or modify a subpoena that 1. Requires disclosure of privileged or other protected matter. 2. Subjects a person to undue burden. Yeah. I think figuring out the IP addresses of every time you log into YouTube or upload a video or watch a video, that's a huge burden. That's unbelievable. Also, personal financial information. That should be privileged. Let's see. Okay, the First Amendment protects the right to anonymous speech, especially on matters of public concern. Very good. B. Rule 45 states regarding the place of issue, production of documents, electronically stored information, or tangible things at a place within 100 miles of where the person resides, is employed, or regularly transacts business in person. Third party to this case, Stephanie Jones of JonesWorks, is currently being legally challenged in her efforts to unmask the identities of unknown accounts and accessing online account information of former employees in multiple districts of California, where she has subpoenaed multiple entities such as Meta, Pinterest, and WhatsApp, Exhibit F. Oh my. This case is getting more interesting by the moment, guys. Oh my gosh. Section 4. Argument. Oh boy. We're getting to the arguments now. A. I am a Canadian citizen and resident. As such, American courts have no jurisdiction over me or my data. Oh my gosh. They're playing the Canada card. I like it. Let's do it. It is considerably more difficult to obtain documents and testimony from non-parties in Canada than it is in the U.S. To be entitled to examine or obtain documents from a non-party in Canada, U.S. litigants must first obtain leave of Canadian court and must show that a non-party's evidence is sufficiently relevant to a material issue in this action. The Canadian court must also be satisfied that the party seeking the discovery of the non-party could not obtain the information elsewhere, that it would be unfair to require a party to proceed to trial without this information, and that the non-party discovery will not lead to undue delay or unreasonable expense. Movement has no evidence whatsoever that any personal information retrieved in any way by Ms. Lively and her counsel would be kept confidential, as they have failed time and time again to redact sensitive information. Ms. Lively throws tantrums about her own privacy and safety on a regular basis, but does not afford these rights to anyone else. Oh my gosh, guys. And you know, if there's one thing that bugs me, it's a double standard, like a real obvious double standard. Oh, trouble. Despite the instances mentioned in this paragraph, the public has not seen a single instance where the court has given plaintiff or plaintiff's counsel the slightest discipline or warning as a result of their professional incompetence in this regard. Yeah, so confidentiality is one thing. I think the other thing that was very important up here in this previous paragraph is really, you know, in terms of going through a Canadian court, it's really this aspect of sufficiently relevant. Okay, I don't see how these subpoenas are sufficiently relevant to this case. That's number one. Also, this item down here, the non-party could not obtain the information elsewhere. If you're going to say content creators have been paid, they're the recipients. So somewhere out there is the payer or the sender of the payment. And if that is presumably Wayfarer or Tag or something like that, then that's a single place you can go to find that information. So I don't think they've hit the items that are required here. So this is a good argument in this section. To compel me to produce documents, Ms. Lively would be required to obtain letters. What is this? Rogatory? Oh my goodness, guys. We've got like Canadian Latin entering the chat. Canadian courts commonly apply a 6-factor test when deciding whether to enforce letters. What is this? Regulatory? Rogatory. Rogatory. It's like Gatorade. Okay. Relevance. The evidence sought must be relevant to the foreign proceeding as determined by the issues raised in the pleadings. So they have to be relevant. Necessity. The evidence must be necessary for the fair determination of the foreign proceeding and admissible to be introduced at trial. So it's necessary. 3. Not otherwise obtainable. Foreign counsel must have exhausted alternative means of obtaining the evidence, such as from parties within their jurisdiction or on consent. So they just could have asked Ashley, gotten some consent. Okay. Or they could have just gone to Wayfair or Tag instead of all the content creators. Very good. Number 4, not contrary to public policy. The request should not require something from a witness that could not be required of a witness in a Canadian proceeding. Ooh, interesting. Okay, so they're saying, like, if we wouldn't do it in Canada, you better not be doing it down there in the United States. Oh boy, that's trouble, mister. Number 5, specificity. The documents requested and topics for oral examination must be identified with reasonable specificity, such that the court and witnesses can clearly understand their scope. And that's a thing we don't have enough of in these content creator subpoenas. Specificity. What does it mean when you say a YouTube premium service? What is that exactly? What do you mean when you say subscriber? Are you talking about the account holder? Are you talking about literal subscribers online? These things need to be specific. Okay, number 6, not unduly burdensome. The request must not be unduly burdensome for the Canadian witness in comparison to what would be required in a Canadian proceeding. Okay, so again, they're saying, look, if we wouldn't put a Canadian citizen through the ringer, you better not be putting her through the ringer, guys, down there in the States. Tell you what. Oh yeah. Next, most of these issues have already been addressed throughout this motion under U.S. law as well. Movement is engaging in lawful commentary on a high-profile lawsuit, a matter of public concern. She is not a party to the case and has no affiliation with any party. The subpoena seeks to unmask an anonymous speaker engaged in this lawful commentary. Plaintiffs have not provided evidence of wrongdoing, much less satisfied the burden for disclosure, merely because movement expresses a perspective disfavored by the plaintiff. Okay, so if you talk mad smack about Blake Lively, you might get a subpoena. These are tough times, guys. Disclosure in this context would chill lawful expression in violation of McIntyre. Okay, so there's a court citation there about chilling lawful expression. We're all familiar with the First Amendment. Furthermore, I am entitled to privacy and safeguarding protections of my data afforded to me under Canada's Personal Information Protection and Electronic Documents Act. Oh my God, that is a mouthful, guys. Let's read that again. Canada's Personal Information Protection and Electronic Documents Act. So that's real nice. I wonder if that's sort of analogous to some of the things in the States in terms of like anti-slap laws or something like that, or obtaining a document through the open document sort of thing. Let's see, FOIA, right? Freedom of Information Act or something like that. Okay, page 7, section B. Google lacks my consent to share my personal information under Section 2702 of the Stored Communications Act. Oh boy, we're getting specific now. Section 2702 of the Stored Communications Act creates an exception based on lawful consent that applies to civil discovery. The SCA authorizes an ECS or RCS provider to divulge the contents of communications when lawful consent has been given to do so. Google does not have my lawful consent to disclose any of my personal information. Okay, so they're saying, look, you can get around these limitations in the Stored Communications Act if you give your permission to Google to give people your information. Sort of an opt-in policy or a consent-based policy. So that's good. Very good. Yeah, and there's a case citation there. The plaintiff in the case citation sought all emails in the 3 individual defendants' personal Microsoft, Yahoo, and Google accounts. The court found the statutory language clear and unambiguous, and ruled that a Rule 45 subpoena does not constitute an exception to the SCA, allowing an ECS provider to divulge the contents of communications. So they're just saying you can't get by with a subpoena alone in this case. Okay, so letter C. Plaintiff filed to obtain a court order before attempting to unmask anonymous accounts. Movement objects to the subpoena to the extent it seeks information about an anonymous YouTube user without first obtaining an appropriate court order as required by the First Amendment. Okay, and we want to follow the First Amendment here. And the case cited here says denying the motion to enforce a subpoena against Twitter, where Movement failed to overcome users' First Amendment right to anonymous speech. Very good. So somebody tried to subpoena Twitter and get some identifying information there. Before a subpoena can be issued to a service provider like Meta for information regarding the identity of an anonymous internet user, the party seeking the information must first persuade the court that there is real evidentiary basis for believing that the defendant has engaged in wrongful conduct that has caused real harm to the interests of the plaintiff. And that's what I was saying in my last video, guys. I don't see a foundational basis of evidence to support these subpoenas. And maybe it's there, and we just don't have it because we're looking at this through the lens of the public perspective on the docket, but we just haven't seen it yet. So it seems like going steps ahead, skipping steps, issuing these subpoenas to these content creators when the basis isn't there yet. That's how it seems to me. Let's move along to the next section. The Highfield Standard is regularly applied, especially in California, where the subpoena was served, regarding the unmasking of accounts on social media. Courts strictly apply scrutiny in these cases, requiring plaintiffs to show 1. A valid legal claim, 2. A strong factual basis connecting the speaker to the alleged harm, and 3. Necessity of the information sought. Oh my gosh, none of these criteria have been met. I was just thinking about that, like, what do we have here? I don't know that we have much of anything except speculation. So I tend to agree there. Let's keep going. While attorneys affiliated with Monat, Phelps, and Phillips may be accustomed to filing sham doe lawsuits, as they have done in this case, to access the entire contents of defendant Jennifer Abel's phone, possibly committing federal and state crimes, where they slip in, file a bogus complaint with pretend causes of action using a client's shell company, serve an underhanded subpoena to whitewash information they may already have in hand, avoid assignment of a judge to avoid the necessary prima facie showing, as outlined in the cases cited above on this page, and quietly withdraw the sham lawsuit with no member of the court ever knowing it existed, the rest of civilization understands this is not the way we do things. Exactly. This kind of, Vince from ShamWow subpoenas to get information from a fake case to use in a real case and slip it in. That's what Omar calls evidence laundering, which is, it's unbelievable. I just can't. If it's okay and it totally makes sense, let's just make it make sense. Explain it to us. We're here to see the evidence and understand the arguments, okay? We can change our mind, but we have to see sufficient evidence to believe claims. Okay, every person being served a subpoena has the right to be notified, legally represented, and protected either by counsel in a standard lawsuit or by a presiding judge who has heard the pleadings and determined the legal necessity of said subpoena in a doe situation, so that does have legal representation to protect their rights. Exactly. Yeah, you need some sort of basic, I don't know, just check it out. Just verification. Some very basic verification, whether that's a judge, heck, even a clerk of court, making sure things are moving along properly. I mean, it blows my mind. I have concerns that not all content creators will have the chance to defend themselves since there is no complete list available for whom Ms. Lively has requested this overbroad, intrusive information from. I request the court see that all Doe-type subpoenas served with the court order from the appropriate district court be revoked, and any future subpoenas of this type be properly filed by Ms. Lively, being required to present her prima facie case to the appropriate district court for a court-ordered subpoena to protect the First Amendment rights of everyone involved. This has not been done in my case so far. Very good. Yeah, dot all the I's and cross all the T's. If you can. Section D. The subpoena appears to have been served by the wrong court. Oh no. What is this? Let's get into it. In accordance with the Uniform Interstate Deposition and Discovery Act and FRCP, I think that's Federal Rules of Civil Procedure, FRCP, Section 45, subpoenas served outside of 100 miles of the issuing court must be issued in the court district of the entity being served. I have included a screenshot of the easy-to-follow instructions on how to properly domesticate a New York subpoena to serve an entity in California, Exhibit G. Oh my gosh, guys, Ashley Brown and Eve is explaining to Blake Lively's lawyers how to do their job. She should be getting paid a consultation fee at this point. I don't know. Some of that Ryan Reynolds Mint Mobile money, maybe. I don't know. Section E, the subpoena is overbroad, unduly burdensome, and without merit. Oh, these are fighting words. These are fighting words. Let's see what we got. The demand for extensive personal data, including banking information and geolocation, goes far beyond what is relevant or necessary. It sweeps in private data of not only non-parties, but even more distant, such as spouses and family members of non-parties who are included in joint bank accounts, live at the same address, share the same phone number, email address, credit card, YouTube account, or the same IP address. And that can happen, guys. We all know that person, those people on Facebook where it's like the couple's account. It's like, you know, Sally and Bobby Techno or whatever, and they're on Facebook and they got the joint account, and it's always picture, and you're like, I never know if I'm DMing them, I don't know which one I'm talking to. These things can happen. Okay, Movement is not a party to this action and should not be forced to bear the burden of compliance, much less have her loved ones exposed to the dangers of every member of the Wayfarer party has so far been subjected to, as a direct consequence of the court continually allowing plaintiff's counsel lack of basic proper redacting. Oh man. Plaintiff cannot offer one single piece of evidence to explain or support these requests. The only reason Movement is being pursued in this matter is because I do not speak favorably about Ms. Lively. Her husband, who was originally a named defendant in this case but has since been dismissed, leaving us to wonder why his name appears on the subpoena as a party, Exhibit D. Exactly. Why is Ryan Reynolds still on these subpoenas? Why do they care about that? He's not in this case anymore. He should be, you know, selling minty, fresh cell phones or something. I don't know. I don't understand. Also, oh my gosh, I digress, guys. But the Mint Mobile thing, they're like, oh, if you're paying more than $15 a month, you're getting ripped off or whatever. The $15 a month is only for like the first 3 months. Corpo guys out there, just set a price and leave it alone. Okay, that's all we want in life. We don't want this special price for a month, special price for 3 months, special price for 6 months, and then they jack the price up. Stop ruining our lives with your price-changing plans, you corpo yahoos. Okay, anyway, I digress. Section F. Disclosure would cause irreparable harm. Movement is concerned about the possibility of herself, her loved ones, and the vulnerable animals at the farm animal sanctuary she runs at her small farm being exposed to the same harm that came to the Wayfarer parties. Oh my gosh, guys. There's like bunnies and stuff. We can't let Blake Lively wreck the bunnies. Okay. Movement has spent her life committed to rescue animals and saving animals from abusive pasts. That's very noble. Safety, privacy, and quiet is of the utmost importance. Exactly. The chilling effect on protected speech due to the fears attached with private information being exposed is profound. Additionally, the court's indulgence of Ms. Lively's outrageous request would set a dangerous precedent, destroying the first basic right of citizens of this country, their First Amendment right of free speech. Okay. And that's the First Amendment. I think the Bill of Rights is anyway. That's the Bill of Rights. The Constitution starts it out. Anyway, I'm splitting hairs. Let's see. Where were we? Ms. Lively and her same law firm, Monat, Phelps and Phillips, that's a mouthful, guys. That's a tongue twister, have already set one dangerous precedent in the course of this lawsuit, namely the Van Zandt sham lawsuit. Oh boy, Vince from ShamWow is running around. Described on the previous page, where Ms. Lively obtained the entirety of the very basis of her retaliation claims spelled out in her CRD complaint, the New York Times article, and subsequent lawsuit, in spite of the New York standard for filing a Doe lawsuit outlined in Sandals Resorts International Limited. Sandals Resorts. Oh my gosh, guys, I need a vacation. Sandals Resorts International Limited versus Google Incorporated, Supreme Court, which states where a petitioner demonstrates that it has a meritorious cause of action, and that the information sought is material and necessary to the actionable wrong. Okay. In this case, the court ruled the petition fails to demonstrate that Sandals has a meritorious cause of action, adding, as the email at issue does not contain assertions of objective fact regarding Sandals, the email cannot form the predicate for a defamation claim based on the first criterion stated above. Furthermore, as Sandals offers no evidence of the harm the account holder's email has caused it, Sandals has failed to prove the fourth element of defamation cited above. Therefore, Google shall not disclose the requested information related to the account holder. Accordingly, it is hereby adjudged that the petition is denied and this proceeding is dismissed. Oh boy. Okay, so that's very good. Let's keep going. Let me just check this. That's looking good. It appears there could be no retaliation claims without the ill-gotten information obtained by the Van Zandt sham lawsuit. Yet this case continues in the court that now baselessly seeks my and 15 others' private information. Ms. Lively must not be allowed to collect such sensitive information to use in a harmful and scheming way once again. The scheming is ongoing, guys. Ms. Lively and her law firm simply cannot be continually allowed to misuse the courts of New York as a revenge machine or a witch hunt against those who speak their opinions about her conduct as a public figure and a party to a public judicial proceeding, the reporting of which is fiercely protected in the state of New York. A revenge machine. I want that on a t-shirt. As we've seen with former defendant, the New York Times, who was granted a stay of discovery, never having to produce a single document before their ultimate dismissal, though their article and video contain information entirely from the Van Zandt sham subpoena, began being written months before any judicial proceeding was ever filed in court, and even admitted that it came from thousands of pages of emails and text and not a judicial proceeding. And I think we saw, with some of the metadata analysis on some of that from some of the investigative researchers on the internet. This whole thing is kind of unbelievable. It's crazy how this happened. I addressed this court with nothing like those claims being brought against me. My information is sought with no claim whatsoever. My and the other 15 subpoenaed parties' information is being sought because Ms. Lively has been allowed to make unfounded claims over and over, striking out at whoever she wants to, using the courts of New York to do so. Lawfare is what we call that. It's like legal warfare. Oh my gosh. She proclaims herself to be the voice of women and vowed to not stop speaking for us while simultaneously causing lasting harm to women after woman, with her counsel and the court's assistance. I, as most of her victims, have done nothing wrong and do not deserve to be unconstitutionally stripped of my rights to suit her whims. Oh my gosh, guys. We are at the whims Let's go on to Section G. Alternative mechanisms exist. Okay, this is interesting. Movement is willing to cooperate with the court through less invasive means, such as submission of sworn affidavits to confirm lack of affiliation and communication with defendants for ex parte, excluding members of Lively's counsel in camera review before the court with no unredacted copies made available to any member of Blake Lively's counsel, parties, or any public filing on the docket. I will submit to a polygraph test on this subject, paid for by Miss Lively. Oh my gosh, she's paying for 30 polygraphs? Let's do it. Line them up. There is no justification for the sweeping public disclosure plaintiffs seek. This is an interesting section because it really points out, when I'm talking about skipping steps and jumping ahead, I think that's what's going on here, because what you could really do is you could ask people to talk to you, give a statement. You could ask people to do a sworn affidavit if you don't believe them, if you think they're lying to you, so that you could set them up, for perjury or something like that, if you think you can prove they're lying. To go right to these subpoenas that go through Google, around the actual parties themselves, it just doesn't make sense. There were subpoenas that were attempted to be squashed in another case that I followed, the Owens versus Dave Neal case. And in that one, there was a very specific process followed to try and obtain information prior to issuing subpoenas. And I may do a video with a little compare and contrast of this subpoena situation with the Owens v. Neal case from California. That was a harassment case. There's some interesting comparisons. There's some interesting contrast as well. So we can go through that. But first we have to read the conclusion of this amazing motion. Section 5. Conclusion. This subpoena fails on multiple grounds. It is breathtakingly overbroad and invasive, putting not only myself as a non-party to this case at risk, but also my loved ones who share bank accounts, credit cards, physical addresses, IP addresses, YouTube viewing, phone numbers, etc. It is baseless since there is not one shred of evidence that I am or have ever been paid by any of the Wayfarer parties or their counsel or anyone affiliated with them. For example, the Tag Group. There is no evidence because it did not happen. It is merely a paranoid fantasy of a person who cannot grasp that people do not approve of her actions. Oh dear. This is yet another misstep that will bring even more criticism to her already shattered public image. And we mentioned the Streisand effect. That's where information about a celebrity gets out. The celebrity wants to hide that information or tell a different story than the information that came out, the factual information, whether it's photographs or a news story. They want to shift the audience's eyes away into a different direction. And that seems to be what's happening here, is that the public doesn't buy it, and the public wants to look at the information with an even finer tooth comb, or a bigger microscope, if you will. So it backfires on the celebrity because they want the attention to dwindle and the attention just ramps up. That's what happens. It fails because it appears to have been issued by the wrong court and without the required court order. Okay, so we have procedural issues. It seeks to unmask my First Amendment right of anonymous publishing. We have constitutional issues. It fails because this is information that should be retrieved from the parties to this case. Substantive issues. It fails because there are other remedies available. It fails because it could cause me irreparable harm. Functional issues and emotional issues. Lots of issues with these subpoenas, guys. This is a great document. Let's see. Let's finish it up. Movement respectfully requests that the court, 1. Oh, there's a list of demands. Let's get it. Let's demand some lunch. I'm hungry. Number 1, revoke this and all non-party subpoenas served on internet providers, phone providers, social media, and streaming sites such as YouTube, Instagram, TikTok, X, Reddit, etc. Oh my gosh. The only thing they're missing there is MySpace. Remember MySpace? You had your top 5. You could listen to some tunes. Some band in Cleveland you never heard of is up there somewhere, and the under construction GIF is doing its thing. Whatever happened to that? I miss it, guys. I miss it. Okay, anyway, GeoCities. Number 2. Let's see. Oh, we didn't finish number 1. Okay, so we have all the social media sites. The subpoenas need to be revoked for sites that have not been properly presented to a court and had a prima facie showing that led to a court order permitting the subpoena to be served. Okay, so follow a better procedure here. Number 2, alternatively, quash the subpoena served on Google LLC for movement 15 and all others 1 through 16. Okay, very good. Number 3, alternatively, allow for lesser invasive mechanisms as suggested in this motion. Number 4, alternatively, narrow the scope and require protective measures. Yeah, exactly. They could redo these subpoenas with more targeted information that makes more sense. They could explain why they need that targeted information. Or number 3 here, they could go get a sworn affidavit instead of a subpoena. That would be much better in my point of view. Number 5, grant such further relief as the court deems just and proper, including but not limited to sanctions for attorney's fees and costs to cover this completely unnecessary and violating subpoena served without court order, cause, or reasonable explanation. It has already consumed days of time in an effort to determine its validity, especially after being lied to by the serving law firm when called upon to authenticate. Oh my gosh. This experience caused and will continue to cause much emotional distress due to the fears surrounding the overly broad nature of the request put upon movement and my loved ones from the moment I learned of the subpoena until the matter will be put to rest and I know I am safe. Respectfully submitted, Ashley, Briana, Eve. Very good. And we'll go through real quickly what the subject of each of the exhibits here, because they were mentioned previously, and we'll just take a quick look at them. But you know, this last section, it really reminds me of this concept in management where when you are at work in an organization and you're dealing with different hierarchy levels of power, managers, executives, people of higher grade level than other employees, and there's a lot of interaction and things. What the people at the higher levels need to understand, these celebrities like Ryan Reynolds, Blake Lively, their actions have the context around their actions is very different than just a regular person. Or, you know, if you're talking a corporation, a CEO, and the context and the lens through which everybody views the actions of the CEO versus a regular employee. It's so different because all of the eyes are on the manager or the executive or the CEO or the person or the celebrity. Okay? And what they can do in terms of intimidation, even if they don't intend to intimidate people. You know, bullying, intimidation, throwing their weight around, right? This kind of lawfare. It has a completely different context when you are a person in a position of power and you're doing something like issuing these subpoenas against people who are not at the same level of power, whether that's wealth or celebrity or job title. Okay, and that's my thoughts on that. Okay, and then at the end, we've got all the exhibits, and this is why this is a 64-page document. Pages 13 through 64 are all exhibits. These are previous court documents we've seen before, previous transcripts, and things we've seen before. But the good thing about this filing is that as Ashley goes through her motion to quash, she cites these exhibits very clearly in particular places, and then when you need to go find them, they're listed here very clearly with what they are in parenthesis. For example, Exhibit A is the email that accompanied my copy of the subpoena that was finally delivered to me at 2:23 p.m. July 14th, 2025. It's very specific, it's very detail oriented, It tells you everything you need to know about what you're about to see in the list of exhibits for this motion. So this is good. This is very helpful, I think, because when she's making claims about something happened in this case, she can back it up with the original document. So that's good, and we like that. Okay, I'm not going to go through all the exhibits or all the exhibit cover sheets. I just wanted to give you an example. You can go on Reddit and read even more of these motions to quash. There's going to be, I think we're at a half a dozen minimum on the docket right now. There's going to be more, and it's going to be interesting stuff. Guys, tell me what you think in the comments. Hopefully, if you listen to this in order to like fall asleep or something, hopefully you're asleep by now. But if you've stuck around this long, thanks for hanging out. I'm Bruce from Oregon, the Bruce from Oregon Show. This has been Ashley Briana Eves, motion to quash in the Blake Lively versus Justin Baldoni lawsuit. Have a good one.